All right, well, I guess I will go ahead and get started. Again, welcome to our live virtual event. And this is Probate Essentials for Real Estate Professionals with myself, Troy Meindertsma. I'm the local regional sales and marketing representative for West Palm Beach County. Also with Melanie Dawn Molina Wood. She is our educator for all of Florida, and our underwriting attorney, Lee Offir. So a couple of things on why Sunbelt Title. With over 45 locations throughout the state of Florida, it is great for not only our convenience, and we also employ over 100 title experts statewide. I think it's closer to 140. We partnership with title companies across the nation, and we've been in business approximately 32 years. So we have the stability and longevity that is essential to have a successful business. So quality and service and proactive communications are our staples. You know, nothing can't be overcome with effective communication. I state that in all my sales meetings and all my classes that I do. And advanced industry technology, which I will be going into right now. Oh, excuse me. Some of the tools that we utilize that I do classes on as well. Obviously we have Zachem for our virtual escrow deposit options. We also do our Pulse Point. It is a text notification about key milestones within your transactions. Spotlight, which will be coming to you very soon. It is a mobile video marketing studio, which coaches and services coaching services that will help you grow your business, and our ever so popular Title Snap. It's our one-step application for your title and settlement calculations, basically in a snap. So just wanted to go through a couple of other things with regards to our custom closings. You've all heard me speak about RONs, and if you're not familiar with what a RON is by now, it is a remote online notarization. Basically, what this means is that we can sign any and all sellers if they are a little bit tech savvy, or if they can do what we're doing right now, get on a video call remotely and online. We can also do this with cash buyers. Cash buyers are able to sign as well, as long as they are, again, a little tech savvy with regards to getting online and getting in front of a computer. And then also some banks now, from what I've experienced, have also been able to accept wet signatures. So it would have to be with lender approval, but we have been able to do some RON closings with lenders, but most lenders right now are still requiring wet signatures. So with that being said, if they have to come into an office and they don't feel like coming directly into an office, we're doing hybrid or curbside closings. And when I say this, it means they can DocuSign the necessary disclosures that don't need to be witnessed and notarized via DocuSign, and then come in, pull up in their car, and what we do, we'll walk out to the curbside, we'll hand over the documents to them, witness them, have them sign, take their license. Obviously, we need to make a copy of the license and walk back upstairs, do a post-close, and then they can just wait patiently in their car, never stepping into an office. If safety is that serious to them, we will accommodate them with, again, proactive communication. So again, when I say proactive communication, I mean, that's what it's all about. We can overcome any obstacle. We can make sure we can schedule anything. We can make sure that we address all your needs, wants, and have a smooth, seamless closing. With that being said, I'm going to turn it over to Lee. Melanie, unless there was anything you wanted to say, I think that would be a no.
No, we'll turn it over to Lee, but Lee, please do give us a little bit of your background.
Yeah, sure. It'd be my pleasure. My name is Lee Offir. I'm State Underwriting Counsel for the state of Florida for Title Resources. We are the title underwriter for Sunbelt. And really, I've been practicing for what feels like forever. I think it's been around 16 years now. I'm board certified in real estate. And I love to go around and talk about these wonderful topics that you guys love. Today, we're going to be talking about probate. If there are other topics that you do want to hear about, stuff that you really feel like it's been a while since you've heard, or anything else, don't hesitate to drop a line to Troy and Melanie. And, even if we don't offer the class, we'll put one together for you, depending on what it is that you guys want. So, again, we're here to talk a little bit about probate. We're going to go over the basics of probate and kind of give an overview about the process and the terminology and kind of how it interacts with real property in the state of Florida. If you have any questions, throw them into the Q&A box, raise your hand or into the chat box, and we can see if whatever it is that we need to answer, we can do so. It's really not, I'm not worried about interruptions. I'm not worried about anything like that. I kind of want to take our time to really understand just the basics of what it is that we're discussing. So with that, basically, what is probate and when does it start? And death triggers probate. It's automatic. As soon as somebody passes, that instant of life leaving their body is the instant in which their assets are technically in limbo or transferred to their heirs, depending on what needs to be done. So what is probate? Probate is, all it is the legal process of winding up the affairs of a decedent, right? And making sure that all the liabilities are taken care of, the assets are distributed, their wishes are fulfilled, etc. All that stuff. So how do we do that? We do that by gathering their assets, and when you gather assets of a decedent, because they're no longer alive, the whole goal is to make sure you protect them. So you gather somebody else's assets, you're entrusted to protect those assets. Pay some of the last debts, not all debts, but pay some of the last debts depending on what the law requires or whoever makes a claim on those debts that are owed. Taxes, because Uncle Sam will always make a claim on those taxes, so you make sure those are paid. And distribute the assets based on the desires of the decedent, right? If it's an outward expressed desire, it'll be in the form of a will. And if it's a desire that's not outward and expressed, it'll be in the form of the intestacy statutes, right? Whatever the state law deems as the proper order of distribution will go, which is the importance of a will. In the event that you don't want them to go at the way the state directs them to go, which we'll get into, that's the purpose of the will. So what happens if there's competing claims for the property? Sometimes there's creditors seeking to get paid. Sometimes the government wants to collect, and sometimes you just have infighting within family members. And so what happens then? Realistically, you go from a calm, direct probate proceeding to what's called a contentious probate, right? A litigated probate that now we're all of a sudden competing claims for certain assets. So that's when it gets really interesting and drawn out, and in some situations heartbreaking. I've been involved in contentious probate litigation that had to do with the fighting over the deceased father's ashes. For whatever reason, they couldn't agree on what to do with the ashes or split the ashes, and so they decided to litigate over that. And I've been a part of it where they're litigating over dogs, and it really is just, it's a way to tear up a family if you ever ask for one. So, ideally, if you sense there is going to be some sort of competition for claims, the best way to just get that right out of the bud is just to make sure and to go ahead and put it in a will and put it in writing. So really, let's take a step back. What are we talking about with terminology in probate once we get into court? So you have your personal representative. In some states, they're called the executor or executrix. In some states, they're called something else. In Florida, they're called personal representative. Basically, it's the individual that is charged with winding up the affairs. It's the person that the court appoints and basically gives them a new hat. It's a hat of a fiduciary, right? Think of a big giant cone hat you put on your head. And now all of a sudden you bear certain responsibilities as the personal representative by law. By law, you are a fiduciary, which means you're entrusted to protect those assets. You can't let them go to waste. You can't hold on to somebody's property and know that the pipes are leaking and watch it go to a disastrous nothing and waste the value of it, because somebody needs to be in charge of that. And if you're going to marshal the assets in court through a process called probate, and you're the one that is appointed to be in charge of that, then you're going to be the one that's bearing the responsibility. So the personal representative. What is a curator? Sometimes, in some instances, you have a temporarily appointed individual to control an asset when there is a dispute. So if the heirs are also the PRs, but they also dispute over where this should go, the court will appoint a third party to make sure that somebody's preserving that asset while we get that infighting taken care of. The will, a lot of you already know what a will is. It is a written document, written. I want to emphasize the fact that in Florida, it must be written. It's a written document that sets out how a person would like their estate wound up. I would like my Ming Dynasty China to go to my daughter upon the death upon my death, or I'd like my G6 jet to go to, my nephew because he likes, whatever it is that you're talking about. You want to make sure you put it in writing in your will, and you want to direct those assets. It could be as simple as, I want my house to go to my kids or to my wife, whatever it is. You want to make sure that your wishes, if you have specific wishes, are in writing. So what's a codicil? We hear these terms sometimes. A codicil is merely an amendment to a will. Back in the day, you used to have to handwrite a will and carbon copy so that there is a copy of it. And sometimes it was with a typewriter, for those that remember what a typewriter is. And if you ever had to make a change to the will, it wasn't as easy as opening up a Word document at the lawyer's office, changing the terms and reprinting a new will. So they added what are called codicils. Codicils basically just say, hey, we're only amending this portion of the will, or we're amending the entirety of the will, and these are the places what we're changing. Nowadays, it really is easier just to have, because of word processors, because of Microsoft, because of everything else, just to open up a Word document, go ahead and make your changes within that document, and then get it out to everyone to sign. The execution requirements between a codicil and the will are the same, in front of the notary with witnesses, etc. So really nothing changes, except for there's just no reason for a codicil. Nowadays in wills, you'll see the language, this will cancels out or terminates or voids any wills or codicils coming before it, because at this stage, that's all we need nowadays. So you'll rarely see codicils, but if you ever do see something called a codicil, all it means is an amendment. Testate and intestate, right? So what is testate? When somebody dies with a will, they had a will that directs where their assets go, their estate is called a testate estate. Their probate will be a testate probate. This tells the judge and the world that there was a will. Intestate means there was no will. It's the exact opposite. Pardon me. It was the exact opposite. It just means that the probate itself is going to go and follow the guidelines set forth in Florida statutes, because there is nothing in writing to indicate any other wishes, any other intentions, etc. The testator or the testatrix, that really is just the individual that put together the will. Right, the settlor, the grantor, the testator, all those are the same person. If I'm writing a will and I'm signing that will on my behalf, then I'm the testator of that will. Per stirpes, sometimes confused with per stripes, right? But it's not, it's per stirpes. And it is a very antiquated term in legal terminology in Latin that nobody uses anymore. But all it means is that upon my death, the people who are to have been taken based on the ancestry only take their deceased ancestor share that they would have inherited. So it's confusing. So let me put it this way. Joan dies with two kids, A and B, right? A passes, or A passes, and A has two kids. We'll call them C and D. So when Joan dies, per stirpes doesn't mean that because she has one deceased kid, the other B gets everything. Per stirpes means B gets his half, and then C and D will share in A's half. That's all that means. So it just means that my interest will pass to my kids, etc., from my parents, as opposed to my brother taking all the interest. So per stirpes is the legal principle by which we want somebody's interest that passes to them to pass along their inheritance line. So inheritance heirs, we've all heard of heirs, people who inherit a decedent's property regardless, are called heirs. That's who they are. They are somebody who can expect to inherit from another's property. Devisees are beneficiaries under a will, right? So you have heirs and you have devisees, and sometimes the heirs are devisees, and sometimes the devisees are heirs. All it really means, you're talking about the same class of people that receive from another property from another estate, right? They're devisees or they're heirs. The difference is devisees are identified in a will. Heirs are not. Either way, that's how it works. And so devisees devise. A devise is basically the reference to the gift, to the direction of where you want that particular property to go out of. Some wills, especially from New York, some wills that are a little older will use the term bequest as opposed to devise. I bequest my goldfish to my aunt, or I devise my goldfish to my uncle. They both mean the same thing. And then pretermitted, a child or spouse who is either born or becomes a spouse of a deceased person after the deceased person created a will. So for example, you create a will and you're a single person, and then a month later you are married. Now you have a pretermitted spouse, which means you did not contemplate this individual in your will because they were non-existent. The same thing with kids that are born after the will is created. That same premise is out there. And so the issue becomes, well, just because you didn't contemplate them then after you got married, now should you have contemplated them? Did you want to contemplate them? Did you want to provide for them? I say if you have a big life-changing event like marriage or the birth or death of a family member that would have otherwise taken, I would suggest that if you have a will, you update it. It's simple. You know, don't leave room for interpretation on what a judge might think you considered or didn't consider. Update your will. It's not difficult nowadays. It really is just, there's no reason not to. So now that we have all of our terminology in place for what we need, let's talk about some of the basics in how things get rolling. So courts don't know that you died just because you died, and sometimes they don't care that you died just because you died. They only care when they're being asked to administer your estate. So how do you ask a court to administer your estate? With a petition. You petition the court. The same way you petition for an injunction, you petition for a restraining order, you petition for a divorce, you ask, you petition the court. So there's a petition for probate. There can be a petition for a testate, for an intestate, for a summary administration, for a full, doesn't matter what it is. All you're doing is you're making sure that you petition the courts. That's how it starts. And when you petition it, when you petition it, that's when you let the court know whether it was testate or intestate. The petition is the initial document that tells the court, here's who died, here are the circumstances surrounding who's dead, here are the beneficiaries, here is I am the PR, here's the reasons why I can serve as PR. All that stuff you're letting the court know so they can open up a court file and they can start the probate process. The will. So what determines a will to be valid is a matter of state law, right? And so every state has different requirements. Every state allows different levels of formalities in a will. Some states will allow you to put a will on the back of a napkin. Some places will allow you to record a video will. In Florida, you need to have certain requirements, which we'll get into in a second. But if you're ever curious and wanted to read the statutes, it's 732-501 and 732-502 that deal with the formalities of a will. So to be valid in the state of Florida, a will has to be in writing, right? So typed versus hand-typed, or handwritten, really. Handwritten wills are called holographic wills, and are an issue in the state of Florida. Typed wills show an intent that it was typed, that it was written out in a way. Then it requires witnesses, right? How many? 2. Same thing as a deed, 2 witnesses. Disinterested witnesses. It's important to be disinterested. You don't want to ever have to support the claim that a will is valid because the witness is related in some way, right? So if ever you have a will, and if there's ever an opportunity for you to get two random strangers to sign off as witnesses, that is the opportunity to do so, right? So it needs to be witnessed by disinterested witnesses. It must be signed by the testator, the person drafting the will, right? It has to be signed by you. If it's not signed by you, it's no bueno. Notarized, right? So how do we notarize it? With an acknowledgement or a jurat? Well, what's the difference between an acknowledgement or a jurat? And we get this question a lot throughout all facets of real estate, right? An acknowledgement is the process by which a notary sits in front of you. You explain to them that you understand the document that you're about to sign, and they confirm your identity, and they take an acknowledgement for you. You acknowledge that you are signing this document, you understand the terms of this document or what it is basically, and therefore they put that stamp on there, and that's your acknowledgement. On the flip side, what's a jurat, right? And so if you ever had to sign an affidavit, if you ever had to swear to something, that's a jurat you're signing at the bottom. A jurat will say, sworn to and subscribed before me on this day. That is proper for affidavits. That is proper for sworn statements, right? An acknowledgement will say, acknowledged before me on this day. That is an acknowledgement, and that's proper for deeds. Some notaries will combine them both and say acknowledged and sworn and subscribed before me. Not necessarily a bad thing so long as all three of those things are actually done, but just so you understand the difference between an acknowledgement and a jurat. Wills need acknowledgements, deeds need acknowledgements, recorded mortgages need acknowledgements, affidavits need jurats. Then you have your specific devise versus your residuary clause. What are those? Those are just different clauses within a will. So what's a specific devise? Lee devises his goldfish to Mark. That's a specific devise. A residuary devise or a residuary clause basically goes through the whole will, doesn't mention the goldfish, and then afterwards says, by the way, any and all assets that I haven't discussed, they can go to Mark. So that's the residuary clause. That's the miscellaneous, everything I forgot to mention, everything else in that box that I didn't give away is the residuary. That can go to wherever I direct it. So what are some weird things that we need to worry about is per Sturpey's language, and we learned about that. If you have a will and you have two kids, and if one of them passes, you want the other one to get everything, you want to make sure that you put that in the will, right? If you have two kids and one of them passes and he has children or she has children, and you want his interest to go to their children, then you put this per Sturpey's language in there, and you have to make sure. What about the effect of divorce? Let's say you did contemplate that marriage, and all of a sudden now you get a divorce. So you got married, you went through all the check boxes, you put together your will, it's all signed, and 3 years later, well, life happens and you get a divorce, right? And so you never update your will, and then you die. Well, now your ex-wife is the one you swore all of your assets to, right? And it was such a nasty divorce, and your kids are left with nothing, and your ex-wife is laughing all the way to the bank, right? No. So Florida has effected a divorce to mean a termination of spousal rights under the will, right? So if you have a spouse in your will and later you get divorced, if you want that person, there's some divorces that just happen and you're still in a wonderful relationship with that person, and you still want them to get all the items you promised them in the will, then you need to do a new will after divorce, and you need to name them again. It can be an exact same copy, obviously with the term divorce or spouse omitted from there, but that can be the way you do it. Pre-terminated spouses and children, we talked about that, and making sure that you make your intentions clear. There's nothing worse than going through the process of a probate in a will and getting everything signed and going back and forth with the attorneys, and then at the end of the day having to defend a term because it just wasn't very clear, which leads us to bad drafting. You know, bad drafting is another item that we want to make sure we stay away from. If the means are available to you and you can go to an attorney to help you draft your will, do so. If they're not and you have to draft your own will, do so carefully. Nothing says you can't draft your own will, and there's plenty of sources on the internet, and I'd say take that advice with caution, because there's plenty of other things on the internet that we see all the time that just blows my mind. So, you know, I always recommend, if you're out of your element, then get an advisor, get a professional. I'm out of my element on taxes. I don't pretend to know how to do my taxes. I have my accountant do my taxes for that reason. I'm out of my element in you know, pool construction. That's why I don't build pools, right? And so same thing in this. If you do not feel that you are comfortable enough to do something in writing or drafting a will, then leave it up to the attorney to go ahead and do that for you. So let's talk about the state of Florida recognizing wills, right? So it will recognize wills that are executed by non-residents of other states or other countries that don't comply with these rules, so long as they're not non-cupative or holographic, right? And so let's take a step back and talk about that first. So you have Florida residents with Florida wills, and they're fine under our statutes, right? No issues whatsoever. Then you have non-Florida residents that die in Florida, but they have an Illinois will or a Texas will or a will from France or a will from Canada, right? And so you have these foreign wills being administered in the state of Florida. And so we're built for that, and we're not worried about that. And we accept and allow them with two exceptions, right? We don't allow oral wills, which are non-cupative, right? They're not written down. They are dictated orally by the decedent and written down by another person, later on transcribed. We don't allow those. Holographic wills in the handwriting of the decedent, generally not signed or witnessed, right? Holographic wills, it's really difficult to tell if that was the person. There's a lot of fraud. Florida just doesn't allow it. You need to have a written will to be admitted in Florida. So if you don't have a will and you go through that probate process and you go through the state statute level of devise, right, what the statute says, I don't have a will or I didn't need a will, and so we go ahead and we go through the state statutes, right? That's called intestacy, as we learned. So what are the rules of intestacy? So basically, if I died without a will, who gets what and in what order? So my spouse would be the first in line to get. If I did not have a spouse, my children. If I did not have any children, my parents. If I do not have any parents, my aunt and uncle. And if I don't have an aunt and uncle, my cousins. And if I don't have any cousins, then it goes up, and there's an entire tree that of all the different people that could be in line to collect your assets. So don't worry. And the good news is, if you run out with all of them, if you run out of all those, then don't worry, the state of Florida will take it. The state of Florida is last in line in the line of intestacies, basically saying that we will find something to do with your property and put your property to good use if we sell it, and or if we, you know, whatever it is that they do with that is sheeted property after the laws of escheatment expire, right? So they don't contemplate being able to distribute to a class of relatives based on anything other than the number of relatives in that class. So if I die and I don't have a spouse, it goes to my children. It doesn't contemplate that this child gets this amount, this child, everybody splits it. Everybody that is in that class, so long as you have at least one member of that class, everybody splits based on the number, right? So it's a split evenly based on the number of people. The rules provide a hierarchy on which relatives will inherit, as we just discussed, and then they go down to the next level. And like I said, at the end of the day, if there is no one to take, then the state of Florida will happily take it. So we talked about the process. We talked about the person having to die first, right? You can't file a petition for probate for someone who's still alive. I've seen it done. It surprises me. It is what it is. The person needs to be dead. The probate is initiated by the filing of a petition. So what kind of petition can you file? Technically, you can file a formal petition for a formal probate, and there's settings surrounding that. You can file a summary probate, or you can file an ancillary probate. Ancillary means non-resident. A non-resident of Florida has property here that we need the courts to go ahead and administer, because it's a Florida property and only Florida courts have authority over it. But this person wasn't a Florida resident. Then what else is filed is called the letters of administration, basically saying this is when you appoint a PR The, 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 the court will issue a document called Letters of Administration, and within that document, the court will say, based upon the petition and everything else, the court hereby finds that so-and-so is appointed as personal representative and shall have the authority. So that Letters of Administration is what gives the PR the authority, the legal backing to do what they need to do. And then obviously submitting a will and an order admitting the will to probate. So if there is a will, you'll submit the will with your petition along with an order admitting the will, asking the court to sign this order admitting this will to probate. What happens if there's a challenge, and there's often challenges to wills, what happens is that then all of a sudden it becomes contentious and litigation ensues, and you have evidentiary hearings, you'll have due process, you might take depositions, interrogatories, everything else that goes into that. There will be an opportunity to have an evidentiary hearing, in which case the court will decide if the will that was presented should be admitted. Not if there's another will that should take its place, because somebody else can always submit a will for admission, but the court decides if the will that was submitted should be admitted. Creditors then get notified. So then all of a sudden you, as the personal representative, have the requirement to notify creditors. So you have to ascertain all known creditors, go through all their bills. Everybody's getting bills every month. Go through their bills and see who are the known creditors. You need to give them notice. Then the unknown creditors, you need to publish in a local newspaper, because, you know, everybody reads a local newspaper anymore. Over here, it's the Daily Business Review. And I can't tell you the last time I looked at a Daily Business Review, even when I was practicing litigation. I'm not sure that that's the effective method of publication, but it's still the current method of publication that we use. So local newspaper, if they're still circulating, they get notice there. Now, once the time limit expires after they receive notice or after notice is published in the paper, creditors then have a length of time in which to say, hey, yeah, you're right, I do have a claim. Hey, guys, I'd like some money, something to that effect, right? And so if they don't do that within the time after they're noticed, or if nobody's noticed and the person has been deceased for 2 years, creditors are barred. They can't go after the claims. Taxes are obviously different because the government makes sure to get its money. But we talk about taxes in the estate. There are two types of taxes, right? There's a federal estate tax, and I'm not referring to the income tax that the decedent had to file on the year that they died, right? So if you died this year, you wouldn't have filed 2021 because it's not next year yet. Those taxes will definitely need to be filed. It's called the final tax return. The accountant can help with that. But aside from a final tax return, there's an estate tax that might be owed. Depending on what year you die in, depends on the level of estate tax that might be payable at this point, right? And so some years it's 3 million, some years it's 5 million. 1 year it was infinity. I think that was 2010, if I'm not mistaken. Don't quote me on that. It might be 08 or 11, but 10 seems to be coming to mind. But basically anybody that was alive and on life support as of December 31st of 2009, as soon as that clock struck and there was 2010 and the estate tax, there was unlimited, so you wouldn't get taxed on the estate. Now, you better believe a lot of people waited to pull the plug until that year came to fruition. Now, you know, some people didn't wait or couldn't wait, and it is what it is, but it just depends on the year that you technically die, and that's the level of federal estate tax that you might owe. We don't have Florida estate tax. We have an affidavit that many people sign. It's taken the form of a DR 312, but literally the affidavit can be in the form of an affidavit as well. Then we can file what's called an order or a petition to determine homestead, right? If the property was homestead. And if the property was homestead and we filed this petition, the court can enter an order confirming that this is homestead, and they'll enter an order determining homestead, etc. Aside from that, we have the PR distribution and the PR discharge, right? And so if it's not homestead, or if there are other assets and the PR needs to distribute it, the PR has to tell the court, hey, I've marshaled all these assets, I protect all these assets, I've dealt with all the creditors. Now I'm ready to distribute to the heirs, and I'm requesting a PR's authority to distribute, and the court will enter an order of distribution. And then after that, the PR says, hey guys, my job here is done. I need an order of discharge. Remember that giant triangular hat you were given in the letters of administration, basically asking, hey, Your Honor, take your hat back. I don't want it anymore. I need a discharge from my responsibilities. And that's how it happens. So that's basically the process of filing. Some weird stuff that we have are disclaimers. You know, if I have a will and I specifically disclaim my eldest son because, you know, my favorite is my youngest or whatever it is, right? Those disclaimers we need to worry about because they have a potential for contentious litigation. And we want to make sure that everybody's on the same page here. Prenups and Anti-Nubs, those are quite common. Agreements made either before the marriage ensued or after the marriage ensued that basically divides or split the assets however the parties agree. That's fine, but that's there. My favorite is anti-killer statutes. I know a lot of people remember the Menendez brothers. That's a good example because they killed their parents. And when they killed their parents, they can't be entitled to any of their assets because we have anti-killer statute. You can't speed up the process of life in order to gain benefit from somebody else's assets. So, you know, like my parents always told me, don't add to the population, don't subtract from the population. This is one of those, don't subtract from the population. Homestead. How does homestead affect all this? Where does homestead come into play? The good news is true homestead property that you live in, it flows outside of probate. It's protected by the Florida Constitution. Courts can't touch it. Why do we have orders determining homestead? Just because the court can confirm homestead status, but is it really required? If all you own is your homestead property, you don't own a car, you don't have any other assets with legal title, technically, upon your death, that homestead automatically transferred per the Constitution or per your will, depending on what it was, but your homestead property passes outside of probate. The only time it'll pass within probate is if you waive your homestead rights to the property, right? I direct that my homestead be sold and proceeds be distributed to Gift of Life Foundation, right? And at that point, it loses its homestead characteristics. It can be attacked by creditors if there were some, right? And so what are some restrictions about your homestead? If you die with a minor child, you can't deed out your homestead. You can't will it out. Your minor child is entitled to that homestead interest. If you die with a spouse only, the only thing you can do is give it to your spouse. You can't do anything. If you die with a spouse and children, man, you just can't touch it. It'll go to your spouse for life, and then it'll go to your children, or the spouse can elect what's called a spousal elective share, which is 1/2 of the value of the property instead of a life estate. And so if you die without a spouse and without minor children, it really depends. It depends on if you have any other heirs in the intestacy statute that are alive, you know, it can go that way. Homestead is an interesting animal. So if you are dealing with homestead property in real estate and probate, I recommend you talk to an attorney that can help you with what your goal for that property will be. So to start wrapping up transaction specific discussions, you know, you have your sale of homestead. What do we really need here? By the heirs, so long as there's a petition, really, if there's an order determining homestead, if everybody was properly named and served and noticed, you know, we clear out the federal estate tax, that property is transferred. If you're doing it with a PR, the PR does not have authority to deed out homestead property. The PR needs to ask the court to declassify the property as homestead in order for the PR to gain access to then going ahead and deeding out the property. So if you have homestead property and you have a PR that is a third party and you have 3 children that are above 18 years old, they don't need to be minors, and that property goes to those children, they have the authority to deed out, not the PR. So that's an interesting nuance to it that we go into, but again, if you have those questions, we can deal with it. Now, non-homestead property is a different animal, right? Non-homestead property is part of your estate, part of your probate, listed in your petition, and then distributed by your PR. So everything that comes with that requirement of distribution by the PR will need to be filed. These are all the documents that we, as a real estate underwriter, right? This is what we would need to look at to make sure that the property was properly titled, properly passed to whoever needed to be passed to, properly distributed with proper authority. Like, we go through all those steps in the background, and these are the documents right here that we would need if the non-homestead property was being sold by the heirs. We would still need the PR unless for whatever reason it fell outside of probate, right? And if it's being sold by the PR, do we need the heirs? It really depends on the situation. Probably not, but it depends. What about if you're not selling it though? What if you're refinancing? You know, sometimes in rare occasions, the personal representative of the estate or the heirs need to refinance the property in order to pay off debts and then sell it, or they need to do certain things like mortgage a property. Well, the PR does have the authority to mortgage a property with court approval, right? And so in order for a PR to do that, to refinance non-homestead property, they'll go ahead and need to get that petition. Instead of a petition for authority to sell, it's the petition for authority to encumber a mortgage. And then the PR can take that once that order is entered and sign on behalf of the estate. Alternatively, if it is homestead and they're refinancing, maybe to take the name off of one spouse off the property or whatever it is they're refinancing, usually it'll be done by the heirs unless that property has lost homestead characteristics, in which case it'll be done by the PR and the heirs most likely. And finally, pardon me, if no probate is filed, and if no probate is filed, you know, do we need to now file one? Sometimes we do, sometimes we don't. Sometimes if it's been long enough and we're not worried about creditors and we have a will and we already know who the beneficiaries are, or we know that it automatically passed, there are ways that we can still avoid probate in order for us to complete that whole process and transfer the property. So sometimes no probate is filed, and that's an exception. Sometimes the probate is closed or destroyed by the clerk, right? So it's been so long that the probate is now closed, we can't get verification of those documents. You know, we might have to take a risk on that. And sometimes the decedent, the person that died, was the actual lender, right? So if they're the lender, they need to issue a satisfaction of mortgage. Well, how does a dead person issue a SAT? Through the courts. Just like the PR's request for the court for authority to sell or authority to mortgage and encumber, the PR would ask the court for authority to satisfy the mortgage, which is technically an asset of the estate. The being a lender and holding that mortgage, that asset that you're owed money for, that's not a protected homestead asset. So that's like it's a standard asset that will go into your estate for the PR to go ahead and issue a mortgage or a satisfaction for. So, you know, with that, let me go back and take a look at some of the questions to see if there are any. If anyone has any questions, don't hesitate to throw them on, and we'll take care of them today. If you guys have questions tomorrow, you know, and you shoot them over to Troy or Melanie, and Melanie Don, we can get them over to me and I can get them answered for you. Or if you go back and you rewatch it and it answers your question, either way, we're here. We're not going anywhere. We're here to answer and help.
So have a great day, everybody, and we'll see you at the next class, which will be tomorrow, 10 a.m.
Take care, everyone.
All right, bye-bye.
Bye.